pleasure to introduce the first speaker of today, Patricia Shaw, my colleague who is a senior negotiator at the EBD-AI project. She's a lawyer by training. She has experience in standards from the BSI in the UK, but also Senelec. She's also the CEO and founder of Beyond Reach, which is a tech ethics consultancy. And she will tell us today about something about transparency, information, and human oversight in the AI Act. And it's my pleasure to give the floor to her. Patricia, it's up to you now.
Thank you very much, Fabian. Thank you very much, Miller, for the introduction. I'm going to take you on a whistle-stop tour. We've only 20 minutes, so I'm just going to start my clock now. And with that, with it only being 20 minutes, I've got quite a lot to get through. We have questions and answers at the end if anyone would like any help with that. And but please, feel free to ask questions. I will do my best during that time to help you and to answer questions as we go. But we've got a Q&A session at the end, so feel free, but otherwise in the Q&A. So transparency, where has this all come from and why is it so important? Well, I want to start by saying it's important how we understand transparency because this gives us access to information and it helps us to facilitate access to justice when it's needed. Transparency went on a bit of a journey with the EU AI Act and it came through 7 principles, originally developed by the high-level expert group on AI, which included human oversight and agency, technical robustness and safety, privacy and data governance, transparency, diversity, non-discrimination and fairness, and societal, environmental well-being and accountability. These undergirded the creation of the AI Act. Now, we know that they didn't kind of get fully translated as was originally intended, but it started the whole process. Furthermore, we can read from the EU AI Act the intention of the European Commission in recital 27, and which seeks to convey some of the intention around transparency. And in the recital 27, it talks about transparency means that AI systems are developed and used in a way that allows appropriate traceability and explainability while making humans aware that they can communicate or they communicate aware that they communicate of interaction with an AI system, as well as duly informing deployers of the capabilities and limitations of that AI system and affected persons about their rights. So there's quite a lot in there, and we're going to look to unpack that. In the EU AI Act itself, there are a couple of clauses really dedicated, articles dedicated to transparency. And the main one I'll be talking about today is Article 13. Article 13 demands, amongst other things, that there be a high level of transparency, that transparency will be designed and developed into the system, such that the system itself and its operation is sufficiently transparent to enable deployers to interpret the system's outputs. That's one thing, but also to use it appropriately. So what's it there for? For appropriate use, and also to be able to interpret outputs. And that's important for us because we're thinking about what are the outcomes of an AI system. It's not just the outputs, but what does this do for people and to people? So with that in mind, we know that also that the AI Act goes on further to talk about and there being transparency to an appropriate type and degree that it shall ensure and achieve compliance with the relevant obligations of the provider and of the deployer under the whole regulation, but most pertinently under Section 3 of Chapter 3 of the EU AI Act. And I mention that because it's a cluster of articles under the EU Act that refers to Articles 16 to 27. I'll come back to those in a moment. But before we go further, I don't want to kind of confound us with science. I want to really think about what are we meaning by transparency, just by a rule of thumb. So by rule of thumb, transparency is knowing what the AI is there for, what it can do, what it can't do, and what you need to do in order to control it and therefore hold it accountable and have it accountable. And to enable the provision of meaningful explanations to those who are going to be impacted and affected by it. That's my kind of simple synopsis of where the AI Act is taking us in this regard. So having access to that information and what available information there is will be key. And transparency is therefore an essential prerequisite for keeping AI and the companies that wield it and who are accountable for it and for their oversight accountable and hold them pertinent for that purpose. And I will always say, you cannot know what you do not know, and you cannot control what you do not know. And I think that's important to remember with transparency. We want things to be made clear to us, and that's what we're looking for. And without the information and without the relevant evidence being made available, how can anyone seek to identify or prove that hazards or a hazardous situation has occurred, or ultimately that there may well be a harm, and especially a fundamental rights harm occurring? We know damage to fundamental rights is hard to prove at the best of times, and when it does occur, proving it and getting compensation for it is equally further harder. So we need a body of evidence, and this is what we're talking about today: access to justice and evidentiary points being pertinent to that. So I'm going to touch upon both transparency and the information that is needed or produced under the AI Act, and then last but not least, oversight with that. So I've mentioned already that transparency needs to be designed and developed into the AI system. And that's an AI Act requirement on providers. And you'll hear me make this distinction between providers and deployers because they have two very distinct roles. But we know that the main people, citizens or consumers and end users who will be interfacing with an AI system will be with deployers rather than with providers. So it's important to understand that there is a distinction in the Act, and that may well mean the way and how you get the information or what kinds of information you ask for may be pertinent depending on the body you're asking it from. So we know that the AI system is supposed to be designed and developed in such a way to ensure safe operation in accordance with the intended purpose through the ability of a deployer ultimately, or a provider making it available, the interpretation of outputs, that's one thing, and the appropriate use. That means use that is in accordance with its intended purpose, that is used in accordance with reasonably foreseeable misuse, but also use that's in accordance with recital 27 that promotes equal access to gender equality and avoids discriminatory impacts and unfair biases as well. And I think that's really important for those of us in civil society and fundamental rights bodies looking to enforce and make sure that systems are producing the right kinds of outputs. So we know that there's going to be that kind of information designed in. So we might want to look at design documentation, specifications, things like that that may well be created. But on the other side of the coin, the EU Act also demands that there be the creation of certain information and conveyed certain information in so-called instructions for use. And this will detail things that are set out in Article 13.3, which is like its intended purpose, how accurate it is, what are the known reasonably foreseeable circumstances which may lead to risks to health, safety and fundamental rights? What are its technical capabilities? How does it perform regarding specific persons or potentially people groups? What details does it have regarding the input data? And this is data that it is used to be trained on, validated and verified, and then how it would then be processed and used as part of its AI good operation. Also, the human oversight measures that are designed into the system that facilitates the capability of interpreting the outputs, and therefore I would argue the need for the understanding of those outputs as well in context. And we also know that the instructions for use will include information like computational and hardware requirements and resources needed, and what is the expected lifetime of the high-risk AI system. And with all of that, we also have requirements on the providers to design in and produce these instructions for use that provide descriptions of mechanisms to allow deployers to collect, store, and I would argue also access and interpret the logs. Now, the logs will be information that is naturally created as part of the good operation of the AI system to record what known are as events. And events are going to be determined by design. So this is an important thing that we need to understand as to what events are captured, and how that's determined in the AI system will determine what's in the log. And if the provider doesn't design the system to record those events, the logs won't have it there. So that's a really important lacuna we need to be thinking about. So, but with the logs, once we have access to those logs, and understand that we can get access both from a 24/7, 365 perspective in terms of time, but also that these logs are in machine readable format or in an ability that can be read by a human or interoperable with a software product that could be read by a human. That makes it important for creating the body of evidence that we will need so that those events can be properly interpreted. Now, these logs are also important for what I will talk about in a moment about Article 14, which is human oversight. But human oversight requires these logs and the events to be there so as to enable people in the so-called hot loop, as in recording, monitoring, observing in real time the operation of the AI system, but also in the so-called cold loop with regard to monitoring the system in review mode. So after the event and having a chance to do some internal reflective practice. So we know that there are going to be logging and monitoring and oversight systems that enable this to happen, and that logs may not all be able to be read and reviewed in real time because of the capabilities of these AI systems and their operation at speed. So just going back to the requirements of the organisation to design the AI system for transparency, this includes allowing access and appropriate use in accordance with all the Section 3 rights that I've mentioned. So it goes from Article 16 through to Article 27. I'm not going to mention them all here because there's too little time to do that. But what I will do is pertinently raise both Article 26 is what is the requirement for the deployers, and then Article 27, what's the requirement for public sector deployers. So with Article 26, there is a requirement to ensure that there is sufficient transparency and the system is designed so that there are appropriate technical and organisational measures in place to ensure that the system is used as intended and in accordance with instructions for use. And that's clear to deployers. So if you go to the deployer and they say, we don't know, you go to the provider and the provider say, did you design this in? So this is the kind of the marriage we have of the two sections. And they also need to put in place appropriate human oversight measures. With that, we want to know what those measures are and how they are expected to be interfaced with humans and with human-to-machine interfaces. So this is also important. And whether additional software is required for that interpretability. We've got monitoring of the operation of the high-risk AI systems to inform providers where they're relevant. So we need that information that's going to be handed to deployers. And where the high-risk AI system is to be rolled out in the workplace, this will include sufficient information for that deployer to be able to inform workers' representatives and those affected workers by the AI system. So this is a whole body of not only information being designed, capabilities being designed into the system, but the kinds of information you would expect to be transferred from the provider to the deployer. If the public sector is a user, we look at Article 27, but with the public sector being a user, it also needs to be a type of system that is registered on the database, and I believe you'll hear more about that later. There also needs to be sufficient information being conveyed to the deployer so that they can conduct a data protection impact assessment under Article 35 of the General Data Protection Regulation. So there's quite a large and high bar that we would expect of that information to be conveyed. So this is the body of knowledge, body of information that fundamental rights, human rights, public sector bodies, national public authorities and civil rights societies who are under Article 77 will be able to demand for this information if it's being made available to others. And last but not least in that list, I mean, there's plenty more, but where there are decisions made or assisted by a high-risk AI system, there needs to be sufficient information to inform those that are being subject to the AI that an AI decision or processing is being made and how that is being made and how it concerns them. And I think that's also important information because we're again asking for not just meaningful information, but meaningful oversight. Transparency is also needed for Article 27 because of the fundamental rights impacts. And I will note here that this is a fundamental rights impact assessment to be conducted where a public sector body is a deployer. Alas, the law does not specifically require public sector AI providers who are providing their services out to do a fundamental rights impact assessment. We in our work in JTC 21 and in the standards are trying to engage in such a way that we can help businesses think about the fundamental rights impacts. We know that's the spirit of the law, but in terms of an actual tangible fundamental rights impact assessment, the one that we're expecting to be created by the AI office as a template, that will not be a requirement for providers to fulfill unless they're servicing a public sector use and or a deployer who is in a public sector user role, and in which case that they may well demand it there. And we know in terms of transparency, Article 50 goes further to ensure that the provider of the AI systems, that people, natural persons like you and I, citizens, consumers, end users, that they know that they're interacting with an AI system. And it's a high bar. It's a high bar that is ensuring that what degree are they to be informed by? They're to be informed to the degree that they can, taking into account the circumstances and the context, that it should be very clear that the user can be well informed, they can be observe and understand in that context that they are indeed engaging with an AI system. So there's lots of things that are happening here on the AI system transparency side. Just to whip across human oversight, again, I ask, what is transparency there for? Transparency is there for, one, information between the provider and the deployer, but two, also within the deployer and the deployer situation, that all-important human oversight. So measures under Article 14 require that they need to be built in. These could be technical and these can be organizational, to the AI system to be provided to the deployer, so the deployer can enable a natural person. This isn't going to be outsourced to an AI system or an AI agent. This is a natural person to conduct human oversight. And largely they're saying human oversight for 5 key reasons. And 5 key ways of them having transparency. To properly understand the relevant capabilities of the high-risk AI system, to remain aware of the tendency for over-reliance on or under-reliance, and automatically reliance, so-called automation bias on a high-risk AI system, so that the human who is in the loop, very much so, gets to correctly interpret the high-risk AI system's output, take into account the current interpretation tools and methods available, and to decide in any particular situation not to use the AI system, or to override a decision made by the AI system, or to reverse a decision by the AI system. And in worst case scenarios, obviously to intervene, bring the operations to a stop, and or indeed need to put the system into a safe state. This is what we need human oversight for. This is why transparency is so important. This is why we need a human in the loop and humans to be in control. But all of this that I've said will create further information, that further information to be made available, whether that's in the design documentation with the provider or the end user instructions, the instructions for use with the deployer. I think this creates lots of paperwork under the Act, as we know. But the EU AI Act is part of the new legislative framework and is requiring harmonized standards to be created, which are currently under development, and we're engaging in that currently. And that will generate more paperwork. Now, I appreciate for those providing and those deploying AI systems, paperwork may well be a nightmare, but for us, this is gold dust. This is important to enable equality bodies and those that are seeking to uphold fundamental rights, especially Article 77 bodies, to be able to get that all-important access to justice. So instructions for use should be given and be provided like a manual to deployers. And if they don't have one or don't have access to it, that begs the question of compliance with the AI Act, first and foremost. But if they do, is it sufficient? And that is really important to understand. And what does it need to be sufficient for? This deployer needs to be able to make risk decisions. They need to understand that there's risk and impact of the AI systems that they deploy, particularly for those that have fundamental rights risks. And they need to know that the provider has considered those, and particularly in the context of operation, that AI system is going to be deployed. Furthermore, you want to know who has decided and who decides, to quote Shoshana Zuboff, as many of you I'm sure will be aware, of the acceptable level of residual risk that applies here in an AI system. That will be designed in. It should be clear in the instructions for use. What kind of data governance is there in place? What kind of selection of data for the training of the AI models has undergone? That was a provider choice. The deployer should know what that provider choice was. and also what kinds of human oversight measures in place. As we did a whistle-stop tour of Article 14, there should be paperwork to know, what do I as a deployer need to put in place? What did you, provider, make available for me to be able to put in place as a provider and as a deployer? And then in terms of the impact on end users, whether they be citizens or consumers or just general people, how have they been impacted effectively? How can I go about giving them a meaningful explanation if I don't know myself as a deployer? So this is all important. So whilst providers will hate us and hate this, information, as I say, is gold dust. And it's important for national public authorities and bodies which supervise or enforce the respect of obligations under union law protecting fundamental rights, as is quoted in Article 77. Now, I know you're going to go more into detail of Article 77 with Fabian and others in the webinar today, but just to say this is a starter for 10. The access to information, the ability to know where this information comes from, who it's going to reside with, is important in your first step to get access to justice for those who are going to be impacted and affected by AI systems. And I will just close here by quoting a little bit from Article 77, because Article 77 bodies will have the power to request and access documentation created or maintained under the whole AI Act in accessible language and format when access to that documentation is necessary for effectively fulfilling their mandates within the limits of their jurisdiction. So that's Article 77(1). And if information is not enough for our bodies to go and process this, to start that journey to access to justice, we have a second secret in our pockets, and that's Article 77(3), whereby Article 77 bodies may have a reasoned request to the Market Surveillance Authority, bearing in mind there may well be many, and it might be tricky to understand which one will have authority, to organise testing of the high-risk AI system through technical means. And better still, the Market Surveillance Authority shall organise the testing with the close involvement of the requesting Article 77 body. And I think that's a second piece in our toolkit: information and access to testing. And so with that, I would like to say, for any of you who want to know more about the work that we're doing by Quality Design, Deliberation and Oversight, or the work we're doing in JTC 21 with the standards for EUA Act purposes, Equinet does have special liaison. I have got a liaison status on behalf of Equinet, so thank you for the honour and privilege of representing people from Equinet. But in that, we have tried to convene and want to convene more civil society bodies and those who are interested in engaging further in upholding fundamental rights in the context of AI through this EUA Act standards mechanism that we have now. And we're currently building a coalition as a bridge to engagement between civil society and the standards. So if you are interested in finding out more or are interested in being part of that coalition, please do reach out. I believe Miriam will put her email address in the chat where you can reach out to us. And thank you for listening to me today. I know I've slightly overrun. Thank you.